Alright guys, welcome to the Smart Education channel. Today we are going to continue Law Reading Torts lecture number 2 in English. Without any further delay, let's get started with the lecture. So in the previous lecture, we first of all discussed lesson outline of our lecture. In the previous lecture, what we really did was, give me a second. What we did was, first of all, we studied general condition of liability for a tort. Then we studied a basic introduction related to tort. Then I promised you that we will study kinds of tortious liability, torts or wrong stop, personal safety and freedom, and remedies in tort. First of all, I would like to apologize because we are not gonna do these three topics. We are gonna do a study detailed of general condition of liability for a tort because they are also very important. In the next lecture, we will start with kinds of tortious liability. So now, without any further delay, first of all, let's do a quick revision what we did in the previous lecture. In the previous lecture, we discussed an example of C and his dog, in which C was hurt by the dog of Mr. A, and Mr. A had to pay damages to Mr. C in order to compensate Mr. C's treatment for the hospital. So what were the general condition for liability of the tort? The first is wrongful act or omission of the defendant. Second one is there must be legal damages in terms of law, and there must be legal remedy. Wrongful act means there is a wrongful act by one person's will or act of a person. Omission means there is a negligence by the person, because in case of Mr. A, he let the dog go alone when he was enjoying his coffee. That was omission of Mr. A. Legal damages means the damages which are recognized by law. Legal remedies means unliquidated damages determined by the court. Now we are going to further discuss legal damages in detail. So legal damages simply means it is not every damage that is damage in the eyes of law. That I previously told you that every damage is not a damage in the eye of law. The second one is it must be a damage which the law recognized, means the damage must be recognized by law. The third point is means the C point. In other words, there should be legal injury or invention of the right. So that two things can be seen by two maxims, namely DAMNUM SINE INJURIA and INJURIA SINE DAMNUM, to determine there is a legal injury or invention of the legal right. First of all, let's discuss a quick example of DAMNUM SINE INJURIA. Let's say that there is a school and the school is enjoying monopoly in a city, but a second school is also open, and due to the second school, the first school loses some profit, and the first school says that because of the second school I am suffering losses, and he says to the second school, compensate me because of your school. Now do you think that the second school should compensate the first school because the first school is suffering losses because of the second school? No, that should not happen, because the first of all, the general condition for liability of a tort has not been happened here. There is no wrongful act or omission of defendant, there is no legal damage, there is no legal remedy. But sir, the first school has still suffered damage. Yes, they have suffered damage, but second school is exercising legal right to do the business. That's the thing here we need to understand here, that because the second school is exercising legal right and the first school is suffering damages because of means losses, the second school is not liable to pay any damages. That is we can understand more detail in DAMNUM SINE INJURIA. It first of all means that DAMNUM means harm, loss or damage in respect of money, comfort, health, etc. Injuria means infringement of a right conferred by law on the plaintiff. And the second point is the maxim means that a man may have suffered damage and yet no action in tort because the damage is not to an interest protected by law of tort. So simply, if I relate to the example, the first school has suffered damage because of the second one, but because the first one has suffered damages, yet no action is taught because it is not protected by law of tort, because the second school is just exercising its legal rights, therefore causing damage however substantial to another person is not actionable in law unless there is a violation of legal right of the plaintiff. The D point is common example are where the damage result from an exercise. The thing that discussed in our example, and the famous case related to is Gloucester Grammar School. Same thing happened. There were two schools and one school suffered damage because of the other one, and the school wanted compensation from the second one, and that's happened in Gloucester Grammar School case. If you do not get the point, comment down below. I will try to explain your query in the comment box of the video. Now let's say that there are elections going on in your neighborhood, and one lady goes to the election booth and she is not allowed to vote because she is black. That happened in Ashby v. Weiss case. What really happened, that a lady went to vote in the United States of America and she was not let to vote, she was not let to cast the vote because she was a black woman, and therefore do you think that her legal right has been ignored here? Yes, her legal right has been ignored here, and since her legal right has been ignored here, she was given compensation for not letting her vote. So what really happened here, a lady went to vote and she was not allowed to cast her vote. That happened in Ashby White case. In that case, her legal right has been affected. More detailed explanation is given in INJURIA SINE DAMNUM. It means injury without damage. So what happened to that lady? There is a injury to her legal right, but there is no damage in terms of physical presence. Where there is no damage resulted, yet there is an injury or wrong in a tort where there is infringement of a legal right not resulting in harm, but plaintiff can still sue on tort. Means when legal right has been affected but there is no harm, then it still can be actionable in tort. What happened to that lady? That lady went to cast a vote, but she was not allowed to cast a vote. Her right has been affected, but there is no harm to that lady. That is the point number A. Some rights or interests are so important their violation is actionable. Means some rights can be actionable even without the proof of damage. C point is same. Thus the act of trespassing upon another land is actionable. Let's say that you go to Mukesh Ambani's house and they put you out of the house by using reasonable forces, even you have done no cause to the house. So that is nothing but what, actionable because you have no authority to go to that land, therefore you can be put out of that land. So that is nothing but trespassing. Trespassing simply means you go to someone else's land and do not do anything, and he kicks you out of that land. That is his authority. So that is nothing but trespassing. Now let's go to the legal remedy. The third condition for liability of tort is legal remedy. The third condition for is legal remedy. The main remedy for a tort is action for unliquidated. Unliquidated damages means those are not determined, they are determined by court of law. So that is nothing but legal remedy. So also some other remedies, e.g. injunction, may be obtained in addition to damage, or specific restitution may be claimed in an action for the retention of charter. Self-help is a remedy of which the injured party can avail himself without going to law of court. It doesn't apply to also imperfect. The best example is trespass to a land. C and D point can be related. Means if anyone comes to a land and with yourself and by using suitable forces you kick out someone from your land, then that is nothing but self and it is even lawful. So that is it for today's guys. Make sure you subscribe to the channel, like the video and share the video among your friends. I see you in the next